just because it's on the internet doesn't mean it's publicly accessible. The Patent Trial and Appeal Board has denied institution of a petition for inter partes review because the petitioner failed to show that its primary asserted prior reference, available through the Internet Archive, was publicly accessible before the critical date. The case is First Solar Inc. versus Ravshan Said. First Solar filed a petition for IPR of two claims of patent owner Ravshan Said's patent, titled Solar Tracker. The patent relates to a freestanding solar tracker with a rotating panel assembly to track the movement of the sun during the day. The solar tracker includes a panel assembly comprising one or more solar panels, a base, a support frame, and an actuator for rotating the solar panel. As the board noted, a patent claim is unpatentable under 35 U.S.C. Section 103A if the differences between the claimed subject matter and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art to which said subject matter pertains. In assessing the level of ordinary skill in the art, factors to be considered include type of problems encountered in the art, prior art solutions to those problems, rapidity with which innovations are made, sophistication of the technology, and educational level of active workers in the field. An expert for the petitioner contended that an ordinarily skilled artisan in relation to the patent at issue would have had a bachelor's degree in mechanical engineering or equivalent with 2 or 3 years of experience involving design, development, and manufacturing of support and mounting structures for solar trackers, with additional education substituting for experience and vice versa. The board noted that in an IPR, the petitioner has the burden from the onset to show with particularity why the patent it challenges is unpatentable. The board also noted that the burden is on the petitioner to identify with particularity evidence sufficient to establish a reasonable likelihood that the reference was publicly accessible before the critical date of the challenged patent, and therefore that there is a reasonable likelihood that it qualifies as a printed publication. A prior reference will be considered publicly accessible if it was disseminated or otherwise made available to the extent that persons interested and ordinarily skilled in the subject matter or art exercising reasonable diligence can locate it. One of the prior art references at issue, Watson, is evidenced at least by its reference on a web page verified by the Internet Archive as being publicly available at as early as December 2, 2005. As an expert explained, the Internet Archive is a website that provides access to a digital library of Internet sites and other cultural artifacts in digital form. The Internet Archive has created a service known as the Wayback Machine, which makes it possible to browse more than 450 billion pages stored in the Internet Archive's web archive. The patent owner asserted that Wayback Machine records were unreliable and that the petitioner hadn't shown that Watson was indexed in a manner that would allow a posita searching for the information to locate it. The board agreed, saying, there was no evidence that the ordinarily skilled artisan would know of Watson or its web address, nor does petitioner offer evidence or even argument that Watson's webpage was indexed, through search engines or otherwise, and thus locatable by a search engine. Thus, the court concluded, public accessibility requires more than technical accessibility. The decision shows that using the Wayback Machine to show the existence of prior references may not be a viable strategy for those seeking to challenge patents. Need to defend your innovation? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.